And with that, I will call the first case of the morning, which is Mann versus City of Detroit. This is a 15-minute mini oral argument on the application. You both have 2 minutes of a free fire zone. You may reserve time for rebuttal if you wish, but we ask that you keep track of your own time if we do not use it up, and you may begin when you're ready.
May it please the court, Steve Hicks on behalf of the plaintiff appellant Kenneth Mann. I will try to reserve 2 minutes for rebuttal. The court has asked one question for us to address in this hearing, and that's whether the sidewalk exception to immunity under the Governmental Tort Liability Act, this would be MCL 691-1402A, applies to the metal pole protruding from the sidewalk that allegedly caused the plaintiffs to trip and sustain the injuries. That's the question that I've focused on in my supplemental briefing. I focused pretty squarely on 1402A as opposed to 1402, the old highway exception. But defense counsel's argument is basically that there is a threshold question in this case, and that threshold question has to do with, basically, what is a sidewalk? Is this part of the sidewalk? And it's singularly focused on the definition that is in 691-1401F. I would note that there's really no dispute about what a sidewalk is. I mean, we all know what a sidewalk is. It's a path intended for use by pedestrians. If you look at dictionary definitions, which have been quoted in cases like Hatch versus Grand Haven, there's a number of different ones, but they all say basically the same thing. Webster's New World says sidewalk is a path for pedestrians, usually paved. And other definitions are basically the same. A walk or raised path for pedestrians along the side of a road. And when you look at the statutory definition, there's really not anything fundamentally different with that definition. It basically has 2 requirements. It needs to be paved, so a dirt path is not going to cut it, and it needs to be, it says in the text, outside of and adjacent to basically a public road. So it has to be those 2 things. It has to be paved, and it has to be adjacent to a public road.
Counsel, what are your thoughts on what is not part of a sidewalk?
What is not part of a
Yeah.
sidewalk?
So, I mean, I understand your argument is if it's
Sure.
probably embedded in the pavement,
Yeah.
there's some other cases
Yeah.
that maybe would exempt
Well,
some things, but what in your opinion is not included?
Well, frankly, I think the cases that the Court of Appeals majority relied on and that the defense still relies on gives us some good examples. For example, in Weaver versus City of Detroit, a bus runs into a street light pole, it falls and hits someone who's on the sidewalk. Well, can't use sidewalk exception for that, sorry. Ali versus City of Detroit, bus passenger shelter collapses on someone. Well, it's not a sidewalk case. So those are good examples, and I think that, typically we see signs, next to a sidewalk. There might be parking signs for the roadway, there might be other signs, but they're not going to be stuck in the middle of the sidewalk.
What if in this case, I mean, we know this was sort of like a sawed-off signpost. What if it was a signpost, it still was a signpost, but it's in the sidewalk, but it actually has a sign on it. It's just for some reason in the middle of the sidewalk.
Yeah, I think it'd be obviously a very different case factually in terms of how it looks. I've never seen that before with a sign in the middle of the sidewalk. I think I would be hard pressed to say that, when you put a sign into a sidewalk, that it's not part of the path that is intended for use by pedestrians. What are pedestrians to do with that sign? They got to go around it. It's in the path. The path is paved. They paved the signpost into the path. So I think you can get there on those facts.
Get where? I'm sorry.
I think you can find liability if a city were to affix a signpost in the middle of the sidewalk. I think you'd basically...
What about a bike rack or a bike rack?
In the middle of the sidewalk?
Not in the middle, in the sidewalk, where
Okay.
you've got a sidewalk and it's. I mean, I've seen that a lot, where it's not off the path, but it's in the sidewalk.
I think the use of the word path there is exactly indicative. This is a path that is intended for pedestrian use. If a And again, I'm assuming that when we use this bike rack example, the sign example, we're talking similar facts where it's actually embedded into the concrete. This is not something that you can just take away, move, slide around. It just somehow got pushed.
Or
over
what
the
if,
sidewalk.
yeah, I mean, we're changing the facts quite a bit, but we're trying to understand how far we're going here. You know, a fire hydrant.
Fire hydrant in the middle of the sidewalk. They can certainly, you know, put, you know, they do that all the time, and that's kind of the point I've made, is you're gonna have utility covers, you're gonna have manhole covers, you're gonna have all kinds of things in the city that could be in the middle of the sidewalk. And I'm having a hard time seeing where the liability would kick in for the plaintiff on that. But is it as to the threshold question, as the defense puts it, is it part of the path intended for use by the pedestrians? Is it affixed into the ground? Yes, it is. I don't think there's a distinction there. Where the fundamental difference comes and where there may not be liability for them is for the plaintiff to actually establish that this is a viable case. You don't just win by establishing, you know, if I were to establish in this case to the court's satisfaction that this metal stub sticking out of the ground that's been cemented into the sidewalk is part of the sidewalk at that point. If I establish that, we don't just walk away and say, well, I guess they're liable. No, they have the defenses. We have to work through 1402A.
So, Counselor,
Yes.
so with the fire hydrant, do you think your case is under A or B, 3A or 3B? And then how would you distinguish that from liability for a fire hydrant in the same location?
Yeah, so you're saying with regard to 3A and 3B, the first one's the vertical discount.
Is it a 2-inch rule case, or is it another defect?
Before I address the fire hydrant, let me address what my case is, because I think your question went to both. And I think our case, it can be viewed as both. I mean, because certainly all discontinuity means is that there's a distinct break in the continuous pathway. And you know, I guess a metal stub sticking up, it could be viewed as that. But I think more logically, this is a dangerous condition in the sidewalk that's not solely a discontinuity defect. And we're talking about a pipe. I don't know that it's really a signpost. Honestly, I looked at it last night, and there's lettering around the base of it that says City of Detroit Monument Control. I think it's a grid marker. Why it has a pipe in the middle of it, I can't answer that question. But in any case, this pipe is 4 inches wide. There's cement inside of it. It's cemented into the ground. So, but to answer your question, I think this case could fit under either, but I think more logically, it is a little bit of both, which sub B goes to. With regard to the fire hydrant, I mean, fire hydrant's a lot taller than this thing, so it's, you know, a lot more noticeable is the obvious factual distinction between the two. Would we view that as a vertical discontinuity? I would say not, because vertical discontinuity has always had some meaning in the law. If you look back as far back as Howard versus City of Melvindale in the 70s, that was the first time I could see that they used it in this context. And they were always talking about sidewalk slabs. Because when you talk about a distinct break in a continuous something or other, here a path, sidewalk slabs make sense. It's the concrete, is it uniform? So usually when we're talking about discontinuity, in the way I think the legislature meant it here when they said discontinuity defect, we're usually talking about sidewalk slabs, and a fire hydrant not going to fit in that. Now, could a fire hydrant potentially fit under B if it's a dangerous condition that isn't solely? I mean, I guess in theory, I'm not sure what the danger is, or what makes it a dangerous condition, other than it being in the middle of the path. But potentially, you could move forward on that case. You might lose it on, as I said, you might not have much luck getting very far with that case on those facts.
It's an interesting question, though, about what's dangerous. I think of the world we live in where people have their head down in their phones. Obviously, that's on them partially, but it is sort of how we use sidewalks and how pedestrians navigate the world has changed a bit.
Yep, and if I could follow up on that, fundamentally, we can focus on the individual and their comparative negligence. Obviously, there could be issues there. But we need to also look at what did the legislature intend to do here in terms of placing responsibility on municipal corporations, specifically in 1402A, to maintain the sidewalks. I mean, obviously, the goal was to maintain that path for pedestrian use and maintain it in reasonable repair. It's not in reasonable repair when you redo your sidewalk and you cement in this, whatever it is, signpost, pipe, monument control marker, whatever it is, and you leave it in the middle of the sidewalk. It is no longer that path. So I think the definitional, the threshold question, I don't think there's any question that we meet it. I think Judge Shapiro hit the nail on the head in his dissenting opinion. But let me turn for a second real quickly to 1402A, because I wanted to be very clear that this is a 1402A case. All the cases that they cite are ours is a 1402A case. All the ones they cite are 1402, which is the highway exception. The highway exception is where sidewalks originally was. It is no longer where the duty is. The duty is squarely in 1402A, and the language is just broader there. These, as the court has said many times, Naraki, other cases, 1401 and 1402 and 1402A have to be read in pari materia. They all go together. They have to make some sense. You can't just turn a blind eye, as the defense has, to 1402A and the sub-provisions that tell you how to beat that presumption, the 2-inch rule presumption. Because as I said, this is probably a sub 3AB case, I'm gonna get this wrong, 3B case. When you throw the A on the end of the statute marker, it always messes me up. But so that's where my argument has focused. The only case they have that comes anywhere close to this, I mean, it's not Ali, bus passenger, it's not Weaver, where we're talking about a streetlight pole crashing down on somebody because a bus hit it. The only case they have that bears any resemblance to this is the Lemieux case, Lemieux versus City of Royal Oak, where you have a guy wire that's coming across, and there's an anchor into the sidewalk there. I would argue that Lemieux was wrongly decided. It is, of course, a 1402 case. It's not a 1402A case. So that alone is grounds to distinguish it. But I don't know that the court has to say it's wrongly decided, because it is distinguishable. It comes under a different statutory section. But most importantly, as Judge Shapiro pointed out in his dissent, plaintiff didn't trip on the anchor. He didn't trip on the thing that was actually affixed into the sidewalk. It was the guy wire that ran by, and I think he was on a bike. I don't think he tripped. But in any case, so I think that's the fundamental problem with the cases that they
So
cite.
the pre-2012 cases, are they all just distinguishable from this case, or do they just not apply because it's before 1402A went into place?
Oh, I think some of them would still have some validity. Like, for example, the defense says, or maybe it was the amicus that said, oh, but now ice and snow is going to be not maintaining in reasonable repair. And in that case, which is Buckner versus City of Lansing, what the court focused on there is the fact that ice and snow, you don't repair ice and snow. You remove ice and snow, but it's not part of the sidewalk. So it's fundamentally distinguishable from this situation. But is it still good law? Arguably that would be, because it doesn't touch the issues in this case at all.
Thank you.
So I'm actually going to have time for rebuttal.
You are.
First time ever. Thanks very much.
Good morning, Sherry White on behalf of the defendant appellee, City of Detroit. As I stated in my supplemental brief, I think this case boils down to the definition of sidewalk, 691.1401F, which defines a sidewalk as a paved public sidewalk intended for pedestrian use. And That's what distinguishes this case from, for example, the Moracini case, which involved a curb cut, which is for pedestrian use. Here, just like the guy wire in Weaver, the guy wire in Lameau, the streetlight pole in Weaver, and the bus shelter in Ali, these things are not part of the sidewalk. And that is the fundamental issue. So you don't even get to 1408(3) A and B if it's not a defect, and the statutory language says exactly that. Even in the sidewalk or in the sidewalk itself. So you don't even get there. The Court of Appeals decision in this case is completely consistent with the statutory definition of sidewalk, and and as I've said, plaintiff has given no reason why the applicable cases, Lameau, Weaver, Ali, are not applicable here. The definition of sidewalk was adopted at the exact same
Counsel, good
time
morning.
and in the exact
Just a quick
same
question.
act.
How do you distinguish from the Shapiro dissent, where basically ultimately the cement was poured all around this obstacle as well as poured into it? Doesn't that, in a way, just make it part of the actual sidewalk?
No, I don't believe it does. It's not part of the paved public sidewalk.
But the cement was poured all around it and into it. It's cemented in.
Well, first of all, there's nothing in the record as to how that came about, first of all.
But it's what exists. The cement surrounds it and is within it. So how is that not part of the sidewalk?
Let me give you an
It's
example.
just-
Let me give you a different example, because I'm struggling with the same thing that Justice Bernstein is struggling with. If I'm making a cake, and there's all the ingredients to make a cake, and then I drop in other things that you don't usually find in a cake, and I bake that in the cake, is that in the cake? Is that part of the cake?
Excuse me?
I'm making a cake, and there's all the ingredients that go into making a cake, and people expect a cake to look a certain way. But I drop in this pen
Right.
into that cake, and I serve that cake. Is that pen part of the cake?
No, it's not.
It's not. So is your position that any municipality can pour concrete and create a sidewalk anywhere they want, over anything that they want, and anything that is sticking out above that is not part of the sidewalk?
Well, as I've stated, plaintiff has never established how that even came about, that the city was responsible for that, first of all.
If the defect were inverted, and let's say you had a 4-inch diameter, 5-inch deep hole in the sidewalk, would that be a defect in the sidewalk?
A 5-inch,
The same, 4-inch diameter, 5-inch height, if we invert it, and that's the size of a hole in the sidewalk that somebody tripped in or on, would that be a defect in the sidewalk?
a 5-inch hole in the pavement itself would potentially qualify.
Okay. You see, help me understand the difference between, you seem to be making an argument that it's, the dangerous condition needs to be, it's of the sidewalk itself, but the statute says a dangerous condition in the sidewalk. So is there a distinction between the legislature's use of the word it's in the sidewalk as opposed to a defect that's of the sidewalk itself?
Well, a defect in the sidewalk is in the sidewalk as defined, which is the paved public sidewalk intended for pedestrian use.
So if a hole or is in the sidewalk, why is this that is vertical, why is that not in the sidewalk as well?
Because
Anything
it's
above?
not-
I mean, are you saying because it's above?
It's not part of the paved, in that instance, such as in this case, it's not part of the sidewalk as statutorily defined. Whereas a hole or a depression, a hole, it can be if it is 2 inches, and it could be a defect, but here, it's not part of the sidewalk as statutorily defined.
So it has-
And the case law points that out.
So what if it was like a manhole cover or a grate, which we see all the time in urban areas when you're walking? There's a grate, and you're walking along the sidewalk, and then one of the slabs is not a slab, it's the grate. And the grate, something's wrong, and it's off kilter or whatever, and someone falls or falls through, like a manhole cover or something. Is that part of the sidewalk?
A manhole cover, for example, I would say would not be. Anything, even a bus shelter was not in the Ali case.
Right. I think what I'm struggling with, I think it's safe to say that when the legislature passed 1402A, I think it was designed to incentivize cities to take care of sidewalks. Is that a fair assumption? Within reason, giving cities defenses
It
and...
clarified some things and established the 2-inch rule to try to establish a threshold for when the presumption of reasonable repair could be rebutted.
So like the manhole cover, that wouldn't be a dangerous condition in the sidewalk of a particular character other than a vertical discontinuity? If the cover's just missing?
I'm not aware of a case involving a manhole cover in the sidewalk. There are numerous cases involving manhole
Sure,
covers
that's,
in
I'm
the
asking,
street.
it's a hypothetical.
That's
yeah.
totally different.
Okay, is that part of the sidewalk or not? Is that in the sidewalk or not?
I don't believe it would be part of the sidewalk.
Okay, thank you.
Council, there's two different subsections to the statute. There's A and B. And A has the in the sidewalk language. And B has, as you've pointed out, the in the sidewalk itself language. And so what language, you seem to be saying A, the in the sidewalk language means it has to be part of the pavement. And so I'm struggling to see what the word itself is doing in the second part if you're reading Part A, the vertical discontinuity, to mean just the pavement itself. So help us understand how we would read those statutes.
I'm not sure why the legislature added the word itself, but I think it's equally clear in both subsections that the alleged defect in question has to be part of the sidewalk. And in this case, it just isn't.
So if there's a 2.5-inch tree root between different sidewalk pavers, that wouldn't be an exception to governmental immunity under the statute?
Potentially.
Why or why not?
Well, if that's established and meets the 2-inch vertical discontinuity, it could between two pavers of the two pavers of the actual sidewalk, if that's demonstrated.
That would meet
yeah.
the statute.
The presumption of reasonable repair would be rebutted. But here, we don't have that either.
So Counselor, the fact that the metal stub existed before the sidewalk was paved, what do we do with that fact? Anything at all? How does that change our interpretation of the statute or how we analyze this case?
Excuse me?
Sorry. I forgot to turn on my microphone. The fact that the metal stub existed before, well, let me ask, did the metal sidewalk exist before the sidewalk was paved?
I don't believe there's anything in the record about that.
I mean, we can assume that it was because the concrete surrounds it and fills it.
I just don't think we have in the record the answer to that.
So the metal stub potentially was placed after the sidewalk was paved? Let
I
us
just don't think we have any testimony about that.
let us assume that the metal stub existed before the sidewalk was paved. Do you think that has any bearing on whether we consider it a part of the sidewalk, whether it was embedded or connected to? Does it change our thought process at all and how we think about the interpretation of the statute?
For purposes of this case, it wouldn't matter because it's not a part of the sidewalk. I mean, if it were a defect that was of the sidewalk, then that would go to the notice issue. But here, we don't get there because it's not a part of the sidewalk.
Is your position, because I think Justice Bolden and I are asking the same line of questions here, is your position that this statute only applies to sidewalk, panels, sections that are poured and are in normal condition, and only if something were to happen after the fact, where one is raising up more than 2 inches, that's the only way that this statute applies? Can you think of any other example?
You're asking whether when the sign
I'm
stub
not talking about the sign at all. I'm asking you if your position is that the city comes in and pours a sidewalk, and the presumption is that as long as it's, these panels set out, regardless of if they're pouring it over something or not, unless one of the panels and where the break is between sidewalk sections, unless one of those lifts up
Right.
more than 2 inches, anything outside of that situation, this statute does not apply.
Right, it's presumed to be in normal repair as long as it's an alleged defect of the sidewalk itself, and either 1402 A3A or B applies, either 2 inches or more vertical discontinuity or another.
And my question to you is that 2 inches or more of vertical discontinuity is the only example that you can give us that fits that, is if a sidewalk were to shift up more than 2 inches or more. Can you think of any other example that this
That would fit
capture?
the 2-inch rule?
Right,
A hole that was over 2 inches deep.
okay, so we
We
could
talked
go,
about that.
okay. And that could be caused,
Vertical discontinuity either way, 2 inches or more, in the sidewalk itself.
okay.
But the point is, it's got to be in the sidewalk itself.
So what if a tree branch, and I think Justice Thomas may have asked this, and I just want to clarify, if a tree branch grew let's just say it grew in the middle or in between and created 5-inch, vertical obstruction, would that be considered if it was not prior existing but came after the fact?
if again it caused a
Mhm.
2-inch or more vertical
Mhm.
discontinuity in the sidewalk itself?
Okay.
Yes.
So are you
And that's-
distinguishing what existed prior to versus what was paved, or what came after the sidewalk was paved, or?
Well, when a sidewalk is poured and it's new, and statutorily sidewalks are presumed to be in reasonable repair unless those two exceptions apply. Things happen, of course, after a sidewalk is poured, we all know that. But the question here is this part of the sidewalk? And it's not. The Court of Appeals ruling, again, as I said, is completely consistent with the prior case law, Lameau, Weaver, Ali, and I do believe that Moricini is instructive here in that it refers to the curb cut and points out that it is designed for pedestrian use, which is what a sidewalk is designed for. So,
If it's not part of the sidewalk, what is it?
excuse me?
What is it? If it's not part of the sidewalk, what is it?
It's a sign stub, and remember, plaintiff testified he tripped on the sign stub. There's no part of the sidewalk was involved in this incident at all.
So
By
I have
plaintiff's
to go
own
back to
testimony.
my question then. So are you saying that a municipality can say, we're gonna put a sidewalk here? And what currently exists is like 50 knives that have been embedded in the ground, and they're sticking straight up, and they're like, we're gonna lay our sidewalk down right here. And because we laid it down, in these dimensions, we're good to go. Doesn't matter what happens. Those knives are not in the sidewalk. They were here before, we saw them, and we just paved right, not even over them, right through them. And the sharp part is 50 knives sticking out. That's not part of the sidewalk. That's not in the sidewalk. Can't get it out, you can't move it. They were there before, and I understand you're saying that the record does not support that it was there before. We're not gonna argue about that. The example that I'm giving, they were there before. Can a municipality just pour concrete, pour a sidewalk, and say, we're good to go? Anything that happens, we're not liable for, under this statute?
This sign stub, just like the guy wire in,
I'm
The
asking,
guy wire in-
I'm
in
asking about the
Monroe.
knives. I'm asking about the knives example.
the bus shelter was attached to the sidewalk in Ali.
I'm asking about the knives and this statute that we're talking about here. I'm asking about 1402A.
It's not a part of the sidewalk as statutorily defined.
Okay.
And the cases that plaintiff says are no longer applicable, it's completely consistent and consistent with the Court of Appeals decision in this case.
Okay, thank you. I don't see any other questions. Okay, thank you very much.
Thank you.
Just real quickly, because I think I only had a minute of rebuttal left. Let me address the Moricini case that came up in the amicus that was filed. Moricini is a curb cutout case. Interestingly, in that case, the city, I think it was Sterling Heights, argued both that it didn't fit within the highway exception and that it didn't fit within the sidewalk exception. Because what they had in that case was a sidewalk that ran basically to the curb, but it was not a regular curb. It was a curb cutout so that, handicap accessible. Basically, the argument was that that particular section, well, it's not part of the road because it's not within improved portion of the roadway designed for vehicular travel, but it's also not part of the sidewalk because it's this curb cutout. That shows the duplicity of the argument here. And I think fundamentally, and it was rejected, the Martini, and I think it was rightly rejected at that time. But it's the same sort of thing here. I mean, their argument all along has been, if it's not the paving material, then we don't have a problem. So if it's a hole in the ground, let's say the pipe was inverted and it went down, they would say, that's the pipe, it's not the sidewalk. If there was just a hole and no pipe, well then maybe you'd have something. With the tree, they would say, well, the tree, if it didn't raise the slabs or anything, if it was just the tree that he tripped on, well, that's like a natural accumulation. It's a natural accumulation of tree instead of ice and snow. So that's where we end up with this argument. And fundamentally, the definition does not require that sort of ridiculous analysis, because all it needs to look at is, was this a paved path intended for use by pedestrians? That's all it requires. Anything else is reading far too much into an otherwise very clear definition. Any questions?
Thank you. I don't see any other
Thank you.
questions. The case will be submitted.